Good morning, everyone. Welcome to today's Facebook Live session. I am Sarah Coombs. I am a solicitor here at TBA Law, and I work mostly in the area of family law. So today we're going to be talking about where to start with separation. So when you're separating from a partner, from a husband, potentially it's a long-term relationship, what you should be thinking about, things you should sort of be aware of, and what's going to happen with the kids, with the finances, the different situations that can arrive. So I guess my first tip and my first point always to make is to remember to look after yourself. Family law separation is obviously a very emotional issue. It's something that brings a lot of distress to a family and creates a lot of situations you never thought you'd find yourself in. So I guess the first point is to look after yourself, whether that be getting help through a counsellor or someone like that who can emotionally coach you through the separation, or just relying on some friends and family members. It's really good to have that emotional support. We as lawyers, even though we listen to your situation, we're more than happy to help. We're often not the best ones to be there for you emotionally, so it's better to have that individual there who's going to support you. I guess another point is that if you've left the relationship as a result of family violence, it's really important that you either seek help or whether that be from the police or whether it be from someone like Nexus Primary Health who can help you move on from that situation. Obviously, if it's a dangerous situation, it's really important that you go to the police, and especially if you have fears for your life or you feel threatened. So they're two very important things to take into consideration. Now, family law has two very distinct branches, and they are either property law or children's law, so parenting matters and financial matters. And the process for both of them is a little bit different. Good morning, Anthony, I can see you there. So for property law, I guess the first step you're always going to take, and the first question we're going to ask you is, what's the asset pool? And so for us, that's figuring out what there is to divide between the two parties. So often, there might be a house, there might be cars, bank accounts, and parties often have superannuation. So as a good starting point, it's often good to start thinking about those sort of things, because the first thing I'm going to ask when you come to see me is, what's the asset pool? What do we need to split up? So that might be you putting together some bank accounts for us to figure out what there is, getting you super statements to figure out how much superannuation you have, and depending on the situation, potentially getting a valuation of your home, because that's often the biggest asset to be split. So that process is called financial disclosure. We'll always give you a list of what we need, but that's a very good thing to start thinking about in terms of separation, is how you're going to divide that. And armed with that information, often it's good, if the situation warrants it and if it's appropriate, for parties to have a bit of a discussion about the finances themselves, because although we're more than happy to get involved, the process can be a lot less painful, a lot quicker and a lot cheaper if parties can just agree. So where appropriate, we really do encourage people to have a bit of a conversation about the financial situation, who's going to split what, who's going to take what, and the like. It's often probably worth discussing as well, if you are living in a house together, who's going to stay in the house, whether you're going to stay living there, or what's going on. So there's a few different options, I guess. So it's really important that you sort of have those discussions if you're able to. If it's not a situation where you can have those discussions, then it's probably better you come see us so we can do the negotiating for you. Now, the other aspect of financial separation is that if, for example, you and your husband, you own a property together, so you might own a house, but then there's a second property that perhaps only your husband owns, but that you've put money into, that after a 20-year relationship, you've both worked on that property together and the like, it might be worth considering how to protect those assets. And the most common way to do that is what's called a caveat. And that essentially registers your interest on the property and prevents it from being sold, or potentially it's a warning to any potential purchasers that someone has an interest in that property that needs to be dealt with. We can lodge a caveat for you at pretty minimal cost, but there are some requirements that need to be met, so we do recommend you come in and have a discussion with us before you go ahead and lodge one. People can do it privately, but it is all sort of electronic now, so it's easier for parties to get a lawyer to do it. And that caveat can be removed at any time when you agree to it, or when you've come to a financial agreement. The other side of the coin is the children's matters that are afoot potentially if you have young children. And again, the first step is always, if you can have a discussion with your partner or your ex-husband or something like that, it's always important to do that. again, it's a very emotional issue, and if you have that ability to have that discussion, it's going to make life easier moving forward as well. And obviously with children, the other thing to remember is that you and this person are going to have an ongoing relationship and shared care of that child potentially for, up to 18 years, and you'll always be involved in one another's life to some extent. So if you can sort it out amicably, that's very important. If for whatever reason you can't have that discussion with your partner, again, it's circling back to my first point, it's very important to make sure that everyone's safe and that you're acting in the best interests of the child at all times. So if you are in a family violence situation, you are concerned for the safety of your child, we do recommend that people take the child potentially and have phone contact or supervised contact or something like that. It really depends on your situation. But again, the main priority is making sure those kids are safe and you as a parent know that you're doing the right thing by them. Now, if for whatever reason you've had those discussions, you can't come to an agreement, the first thing we as lawyers always refer you to is what's called family dispute resolution or mediation. This is always the first step in a children's matter that needs to be done. It is a requirement of the court before you lodge legal proceedings as well, unless you have a certificate. And a mediation really enables the parties to have an open discussion with a third party present who can be there to facilitate discussion. It's really there to encourage parties to come to that own resolution without the intervention of the court. And we really prefer it because, like I said, you're going to have this ongoing relationship with this person for, years to come, and having been able to have that discussion, come to an agreement is very important. Mediation, like I said, it is a bit of a discussion more than anything else. They cannot make binding resolutions there. The mediator can't even make a decision for you. You as parties need to come up with that decision, but the mediator there facilitates the discussion and makes sure everyone's, being heard. Once the mediators made the decision, once the mediators had that discussion with everyone, and if you can come to an agreement, it will often be drafted up into what's called a parenting plan. And that's document, although not legally binding, is recognised by the courts, and it will help you and your ex-partner govern what you're going to do with the children. So, it might be that your child spends Monday to Friday with you, and then they go, with the other person for the weekend, and then they get a couple of nights with the other person, the next week. It can really sort of help deal with those issues. And a parenting plan can be revised as often as needed. Once you've got that mediation agreement or parenting plan, we can formalise it in consent orders as well. So once it's all agreed to, we can actually write it up, take it to the court and say, here, we've come to this agreement, can you please make it as a binding court order? And I guess the main thing we recommend with both children and financial matters is that before you really begin some serious discussions, even if you're having those yourself, that you come to a lawyer, even before you go to mediation, or if you're just going to discuss it with the other party, come to a lawyer, have a discussion about what your rights are, and that might equip you with the tools moving forward to have those discussions without a lawyer. And it also gives you sort of an idea of your options. So, if you come to an initial appointment with us, we will, for example, for financial matters, we'll go through what your asset pool is, what your contributions to the asset pool were, and your future needs, and sort of figure out what a rough figure that you might be expecting to get. So we'll set your expectations as to, what you're likely to get if the matter proceeds further. We'll also go through the different ways you can finalise a matter, whether it be parenting or financial, which our preferred method is consent orders. But we'll also, potentially give you some negotiating techniques, what to look out for, what you should be asking, the questions you should be asking when you're having these discussions, to make sure that you're getting your point across, and, sort of not being railroaded, I guess. Again, with children, even before you go to that mediation with family dispute resolution, before you go to that, you might want to come see us, and we do recommend people do, to figure out what's going to be a realistic time with the kids in the future. So, if you're a father and you've got a young baby and you and your partner have just split and you've got a child that's still breastfeeding, it's not realistic to expect overnight time straight away. So, that might be something that you have to build up to over a couple of years while the child's still dependent on mum. So we can help set those expectations. But it's also good to know your rights if everything doesn't work out and you do need to proceed through the court process. And we can go through that very generally for you and set out what the costs can be. Circling back to my main point though, throughout the whole process, it is very important that you're taking care of you. As lawyers, we're not really qualified as counsellors or emotional support. We are we are partial towards our clients. but we are the reason and the logic in the situation and what is a very emotional situation. So we do recommend that you see help from a counsellor or a psychologist, and potentially family violence counsellors if that's appropriate. So I've gone through the main points I wanted to go through today. Like I said, my main point is come see a lawyer. Take an hour of your time. There's some fees involved, obviously, but it will give you some tools to move forward with, even if you don't want to have a lawyer involved going forward. So if anyone is interested, we are more than willing to have family assessment conferences with you. It just takes an hour and we'll go through your situation and give you some advice. But overall, they are most of the tools you'll need to start with separation, and obviously getting that help that you need emotionally as well is very important. And thank you very much, Anthony. If you've got any questions, please do not hesitate to contact our office, send us an email. I'm always happy to have a quick chat if that's what's needed, and we can go from there. Enjoy your Tuesday. It's a beautiful sunny day, and I look forward to hearing from anyone who's got any questions.